Please the court. I'm Mark Stupp, a counsel for the appellant. I would request 5 minutes for rebuttal.
Sure.
Your Honors, there are two reasons why the lower court erred when it denied our motion for prevailing party attorney's fees under the reciprocity provision of 57105 sub 7. One of them is a straightforward reason. One of them is a complicated explanation. I'll start with the easy one. The 5th District just last month issued a decision on materially indistinguishable facts. In Madel, the 5th District ruled that notwithstanding the 4th District's decision in Glass and the 3rd District's decision in Fitzgerald, that when a borrower wins a foreclosure case, even based on the plaintiff's lack of standing at trial or failure to prove standing at trial, that attorney's fees are required for the prevailing borrower where there was an assignment of mortgage to that borrower, to the lender that prosecuted the suit.
I have a question about that.
Sure, Judge.
I read Madel. It's interesting. And I agree that the equities are probably in your favor here, but we need to talk about the law. So Madel finds that there's an assignment when the assignment wasn't even admitted at trial. But obviously it's in the record. The assignment here is admitted in trial. It's a 2012 assignment pre-suit, assigns the note and mortgage. But Madel also makes reference to not only the assignment, but standing at trial. And Madel even distinguishes a case called Rushlow, where Rushlow they found lack of standing at the inception and at trial, and seems to emphasize that that's a distinction. My question is this. Is the real issue here whether there's proof that Harris and Bank of New York were parties to a mortgage? Is that the real issue?
I think that's...
Or does some sort of standing need to be proven?
Well, I think that's a complicated question, and I'll answer that by going back to, I was starting out by saying there's a simple version and a complicated one. The simple version is this is a straightforward Madel fact. You call it Madel, I call it Madel. I don't know what the right answer is, but it's a straightforward Madel fact pattern. There was an assignment of mortgage. It was Exhibit 3 in evidence. It assigned both the mortgage and the note, and there was a blank endorsed note introduced into evidence at trial. Those are the exact same facts that we have in Madel, and so I submit following those same facts that this court could be a very simple decision. You know, we reverse the order denying the motion for fees, see Madel. That's, you know, I mean a little more than that, but it's a very simple analysis. And I submit, in fact, that there is no way for you to affirm the order on review without certifying conflict with Madel. If you ask that question to my opponent, how would you distinguish Madel, or how could we affirm without certifying conflict with Madel? I submit that she won't have an answer to that question because there is no answer, and that's not to impugn her at all. But there's no way to distinguish Madel at all, which to me is whether you look at it as, well, are they a party to the mortgage? Are they a party to the note? You know, I think the answer is under Madel, they're a party to the mortgage because the mortgage is what has the fee provision. And so if there's an assignment of the mortgage, even if it doesn't include the note, then that still means that the lender was a party to the mortgage, which has the fee provision. So under their even under their analysis, that's sufficient to require fees. And we certainly have that here because not only was there an assignment of mortgage, but there was of the note as well. So you can avoid complicated questions and simply follow Madel.
Can you enforce the terms of the mortgage without proving any type of standing?
Enforce the terms of the, well, I don't think that's I understand the question, but I don't think that's the appropriate question respectfully to be asking.
Because I think what Alexander and Glass are doing is if there's a finding of lack of standing, that voids the contract.
Well, and this gets into the more complicated analysis, and I submit to you that the Glass and Fitzgerald are distinguishable in this case for the same reasons that Madel distinguished them. But I also submit in the more complicated analysis is that Glass and Fitzgerald are wrongly decided. And I know that sounds like a strong statement, but bear in mind that the Florida Supreme Court has already accepted conflict jurisdiction in Glass, which to me necessarily means that they think Glass was wrongly decided, because otherwise what basis is there to assert conflict jurisdiction except to say that Glass is inconsistent with the Florida Supreme Court's own decisions in Katz and David, which is the very analysis that we made in this appeal as well. And so I submit, to answer your question, and the argument here is you go to the plain language of 57105 sub 7. And the statute doesn't contemplate a standing analysis like was made in Fitzgerald or Glass. It contemplates, and this is what years of jurisprudence have contemplated, if a contract contains a provision allowing fees to a party when they filed the suit, the court allows fees to the other party when that party prevails. And under that plain language of that statute, the purpose of that, of course, is to level the playing field, or as this court said in First States in 2011, to provide mutuality of fees. The purpose of that, and as many cases have interpreted, is that if a contract exists and the moving party was a party to that contract, then fees are required as a matter of law. And there are many decisions which have construed it just that way. Katz, the Florida Supreme Court, I see the operative distinction as the way the Florida Supreme Court distinguished its cases of Katz and David. In Katz, they awarded fees because a contract existed even though it was unenforceable, so the reciprocity provision kicked in because the contract existed. In David, fees were denied because there was no contract. The contract never existed. And if you look at the cases which award fees or deny fees under 57105.7, for many years, that's been the operative distinction. There's only two types of cases which have denied fees. If the contract never existed at all, such as in Mestre, 5th District 2015, or Choi, 4th District 2014, or Red Road, there was never a contract at all. Or if the party moving for fees was never a party to that contract, like in Strasburger, 4th District 2003. All the other cases which award fees on simple facts. The contract existed and the party moving for fees was a party to it. And that's consistent with the plain language of 57105.7. It's intended to level the playing field because if a party is pursuing a contract claim and fees based on the contract claim, it doesn't matter whether that party actually has standing under that contract. That's not in the plain language of sub 7 at all. What matters is that party seeking fees, the other party was a party to that contract and won the case. So the contract existed and the party who won was a party to it and won the case, and there are legions of cases which require fees under that analysis, and that is the distinction that the Florida Supreme Court sets forth in Katz and David, and I submit that that's why they accepted conflict jurisdiction in Glass, because if they thought that Glass was rightly decided, there'd be no conflict and they wouldn't have accepted jurisdiction. So I realize that case hasn't come out yet, but I submit that where the law got a little muddled and what creates some of these hard questions, it started with the 5th District's decision in HFC in 2016. Now, in that case, that's not the same as what we have here at all, because in that case, and notably, that decision made no mention of Katz and David either. Neither did Fitzgerald, neither did Glass. None of them even mentioned the Florida Supreme Court case.
I don't want to cut you off because I know you got a good point, but Alexander seems to be distinguishable because there was just no proof of assignment at all. There's no proof of contract, really.
There you go.
But Alexander seems to hold that if you don't prove standing vis-a-vis the note, you cannot enforce the terms of the mortgage.
Well, I understand what you're saying, but I don't agree for standing purposes in a foreclosure case, but I don't agree with that for attorney's fees purposes in these cases.
That's what I'm asking.
What happened in HFC, what I call it HFC, I guess you call it Alexander.
Yeah, I'm sorry,
Alexander. No, that's fine. Is that the defendant moved for summary judgment and introduced affirmative evidence of the plaintiff's lack of standing. It wasn't a case like here that turned on the plaintiff's absence of proof at trial. It was the defendant affirmatively moved for summary judgment and was his burden proved the plaintiff's lack of standing. And that HFC decision turns on an estoppel analysis by saying, wait, the defendant can't take the position that the plaintiff was not a part of this and then turn around and take an inconsistent position with that later. It turns on an estoppel. You don't have an estoppel fact pattern in a situation like we have in this case, because my client never introduced any evidence. My client never introduced any affirmative proof. We simply relied upon the absence of proof, the plaintiff's failure to prove its case at all. And that's why I've had many decisions out of this court which have given my client standing wins, and I have consistently received attorney's fee awards on those fact patterns, such as in Your Honor's Buckingham decision that you drafted. Fees were awarded as part of that. And there are many others as well. And that, I submit that that's because there is a distinction under the law between a defendant introducing evidence and then being estopped and simply saying, you didn't prove your case. And look, for instance, at the notice of voluntary dismissal cases. When in the foreclosure context, this court's precedent, as well as the other DCAs as well, make clear when a plaintiff voluntarily dismisses its case, the defendant's entitled to prevailing party attorney's fees. Well, what is the real difference between a plaintiff voluntarily dismissing its case and the court involuntarily dismissing it at trial because the plaintiff didn't prove its case? And I spell out two hypothetical scenarios, and I'd ask that you contemplate these as you contemplate the law in this. The first is a plaintiff comes to trial and says at the start of trial, you know what, Judge, I can't prove my case, I'm standing, I'm taking a voluntary dismissal. On that fact pattern, all the DCAs make clear fees are required as a matter of law. Plaintiff can't prove its case, they take a voluntary dismissal. That's hypothetical one. Now take hypothetical two. That same plaintiff comes to trial and says, you know what, Judge, I can't prove my case on standing, but I'm not going to voluntarily dismiss. I'm just not going to introduce any evidence at all, and I'm going to make you dismiss the case. So then the court grants an involuntary dismissal. Are you really telling me that on that second fact pattern that fees should not be required when they were required on the first fact pattern? Are we really going to encourage litigants to continue prosecuting their cases, to force courts to grant involuntary dismissals when there's an absence of proof, rather than simply have them dismiss cases? That's craziness. Or think about this. Imagine you have a plaintiff who realizes halfway through their case, oh, shoot, we can't prove compliance with paragraph 22 or some other aspect of their case, right? Well, they can realize instead of just taking a voluntary dismissal, they could make a strategic decision to come to trial, intentionally not prove standing, force the court to enter an involuntary dismissal, and then say, well, haha, you can't recover fees. I mean, these sound like absurd illustrations, but that's exactly the point. You can't have a court system that requires fees when there's a voluntary dismissal and precludes fees when there is an involuntary dismissal based on lack